All right, Doug from Salt Lake. Okay, this went out today, May 11th, Saturday. It's 6:30 p.m. This is my affidavit of default. An unrebutted affidavit stands as truth in commerce. And I'm not going to read all this to you. This is a affidavit of default, and I went and got it notarized. And one of the things that I didn't talk to you guys about last time was how important these are. These mailing certificates are important. You have to make sure that you have, some kind of affidavit of service. This one here is pretty simple. I certify, right? You've seen these before. Did you certify mail it? Did you email it? Did you hand deliver it? What's the number? What's the documents? Who got it? And who sent it? Okay, real simple. Please don't forget, every piece of paper that you send should have one of these with it, because even if you send it certified mail, they can just say, well, we never got that document. Well, yeah, you might have sent that envelope, but where's your proof that that specific document was in that envelope? So that's just to cover your ass. Let's see, what else do we have? Okay, so real quick, let's go through what we have sent them. First, we had our discovery without leave. This was the questions that I had about the applicability of Title 4D to my case, and they failed to respond. And then I sent them the answers in blue ink, and I don't know if you guys remember this one, but this is basically, all of the, things that I wanted, and I just wrote them in and proved without a doubt that Title 4D does not apply to my family, because I was never on public assistance or any of that. Okay? Then we send them a law notice of default, non-response. UCC is the Uniform Commercial Code. I wrote down all this, what I sent them, when I sent it, and I just had some questions about the Uniform Commercial Code. Couple of things. Okay, I don't know if you remember or not, but of course they defaulted. So on April 27th, okay, let's go back for a second here. Okay, so back to the discovery without leave. I sent this March, and then we went to the answers. The answers were sent 20 days later, April 13th. And then you can see on this document, I've got it all documented. Okay, this is the third one. This is my UCC. Okay, so everything is documented. Then we sent them a notice of non-response. This was, let's see, what was this one? This one was Saturday, April 27th. So they defaulted. I waited. May 3rd, I sent them another one. And then May 5th, I sent them another one. And let me show you real quick. At the end of this one, I think I went through this one with you. I put at the, see, I got it all here, when I sent everything, the dates, all that stuff. Here's the final notice. And as you can see on the end here, I've got two witnesses. So that's the only difference between this one and this one. This one has witnesses and a true bill. Of course, I put on here an invoice because if you don't add it, then the judge doesn't know what else to do. So this is my verified affidavit of default. This also has a witness, and it got notarized today and got sent out in the mail. And this basically just confirms first-hand knowledge concerning the facts contained herein, provides that this verified affidavit and the employees of ORS find hereby deposes and says, facts stated herein, test and affirm, blah, 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 blah. I swear under penalty of perjury, everything's true and correct and complete. Okay, so I did mail ORS a document entitled Discovery Without Leave, okay, on March to the above address concerning the applicability of Title 4D as it pertains to me and my family. Certified mail number, ORS failed to respond. Okay, that's all fact. Okay, so they can't dispute that. I did it again with the Discovery Without Leave. Here's the date. Here's the certified mail number, notice of default, and opportunity to cure. Okay, because you defaulted on this one. So I gave you the answers to the test, and you failed to respond. Okay, that's a fact. The affiant, whatever it is, did mail, okay, to ORS, UCC contract law notice of default and non-response. So now what I'm doing is I'm pulling them over under the UCC because that's what all this is, okay? All of your conditional acceptance, all of your notices, your non-response, your dishonor, your arguments, going to court, the magistrates, these companies operate in commerce, okay? They are corporations, so they are bound by contract law, okay? So let's not talk about, oh, you violated my fucking rights and all that. I'm a sovereign citizen and I'm a glow-in-the-dark patriot. I don't want to hear all that shit, okay? Let's talk about the law. What's the law? The law is if you're operating in commerce and you're a corporation and you've got an EIN number, then you are bound by contract law, okay? And just like when they send you a notice, if you don't respond, you're in default, okay? Well, they didn't respond, so they're in default. But you have to put it down on paper. Here's another one. I mailed a notice of no civil dispute, dated, blah, 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 certified mail number, okay? ORS failed to respond and has not refuted the facts stated in this document. And that document is considered an opportunity to cure upon proof of claim, okay? So the way I'm understanding this is you get something in the mail from one of these ass bags, and that is a offer to contract, okay? They're trying to, they don't produce anything. These people are leeches. They're parasites, okay? They are cockroaches. Think about it. What does that state office building manufacture or produce? They don't produce or manufacture shit. All they produce is death and taxes, right? Okay, so what do they need? They need fucking slaves. They need customers, okay? And if you don't refute their conditional offer of a contract, then by acquiescence and by what's the word I want to use? Well, I said acquiescence, but by non-response, you basically default and you go into dishonor, okay? If you guys don't know what I'm talking about, I would read the first 4 or 5 chapters of the Uniform Commercial Code, okay? Just start at 1-101, okay? Anyway, this is how you cover your ass, I believe. This is my opinion. Oh, and for the record, none of this stuff is legal advice and all that other bullshit, okay? This is all my opinion. Just want to cover my ass so nobody fucking gets all butthurt. All right, so where are we at? Affiant did mail, final legal notice, non-response. Okay, here's the date. Here's the certified mail number. ORS failed to respond and has not refuted the facts stated in this document. The affiant mailed this one, lawful constructive notice with exhibits attached. So this one here, all of the exhibits, this is my UCC filing, my legal notice and demand. This is my hold harmless indemnity agreement. my fiduciary agreements, my Form 56, my tax forms, my security agreement, my copyright. Oh, that's fiduciary, and that's the Form 56 that goes to, anyway, if you do your secured party, you'll figure it out. Security agreement, hold harmless, copyright infringement notice, a couple other things. I think I sent the discovery and the discovery with the answers. So I sent all that stuff to him again. An invoice for damages was also sent. Common law, man, I always get tongue-tied on that. Common law copyright breach. ORS failed to respond, rebut, or refute any and all facts made in said documents, and they are now considered true and correct. No response by ORS or any other lawfully delegated representative of the said agency or department has ever been received refuting the claims made in the aforesaid blah, 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 notice of non-response, the notice of dishonor, all these notices that I sent to him, okay? And that proves the affiant is the secured party and the holder in due course. And that ORS is illegally administering my property, okay? ORS was granted 20 days. They did not refute, okay? They thereby defaulted. Then I went through it again, and then I went through it again, and again, and again, all my different notices, okay? That's why, lawyers and paralegals and documents from the court are always 27 pages long, because they got to go through everything, and, you're doing all the presumptions and rebutting this and rebutting that and rebutting this, okay? So now, default has occurred, whereas ORS failed to respond to my affidavits. The following facts are hereby established, okay? They are established in accordance with the Uniform Commercial Code, okay? 1-205. You should look this up and read it, okay? No facts are established by ORS respecting facts stated in the discovery and the other documents, and they had an opportunity, and they failed to plead, and thereby they have extinguished the right to proceed against me in this matter. Nunc pro tunc. Remember what that means? Nunc pro tunc. That means from then to now, or from now to then, or from then until now, something like that. That's from the beginning to the end, okay? So from the beginning to the end. The facts contained in this discovery and all the other are considered accurate, as they have not been rebutted by counter affidavit by someone competent to know the law within 10 days required. All matters not denied are affirmed, okay? That is now a fact. Case closure criteria has been met and applies to the above case number, as seen in the discovery. The agency department failed to validate this debt, produce a contract for services as required by law, and has failed to provide proof of claim. By defaulting, you have waived all your rights claimed against me, my all caps name, respecting any collection of alleged child support, the arrearages or penalties owed for the years between 2006 and 2019, and you will agree. ORS will refund all income, and you agree. I'm screwing this all up. And the Office of Recovery Services agrees to refund all income withheld and cease and desist. Okay? ORS and all government agencies in contract with the ORS are estopped from any and all claims against this man, as noticed in the UCC filing, the legal notice in demand, and the common law copyright notice. This case is dismissed. Okay? So I got this dated, notary today, witness today, and now we're ready to move on to either filing a commercial lien or going back to the courthouse and doing an order to show cause. Okay? and we've started to write this up. We've got all the pertinent information, and this is basically, not going to read it to you because I'm not done, but this is going to go to the court clerk, and it's going to go to this punk, Mark Corris. And this is basically, there's a couple more pages in here. I'm not going to read that to you either because I'm not done. But this is to vacate a judgment or warrant lien, restitution, arrearages, et al., and other things. Okay, here's all the case numbers. This is going to be filed concurrently with a notice of claim and an affidavit in support and a proposed order. Okay, so my notice of claim is going to be all those documents that I just showed you. I'm going to have a copy of all of them. I've got all the printouts of the certified mail, and then the affidavit in support is going to be the one that I just showed you. And I'm going to propose an order, and basically the order is just going to say ORS defaulted, they didn't answer, an unrebutted affidavit stands as truth, and I'm going to tell them to vacate the order. So, have fun, you guys. Peace.